when someone is arrested, they're typically brought to an arraignment. And at that arraignment, your charges are read to you, and a judge has to decide whether or not this person will come back to answer the charges, to the court appearances, without there being bail set, right? So the judge will look at the ties to the community. Have you been a lifelong resident of that county?
Sure.
Do you have a warrant history? Have you warranted before? Do you have a history of not returning to court? What is your criminal history like? What are the charges, right? So bail will be issued if the court thinks you may need a little more incentive to come back to court. So we're going to put some bail here. Or if the court is confident that bail's probably not necessary here, because bail is set to assure you'll come back, not to punish the defendant because they believe the crime is heinous.
And let me ask you this. Are there situations where the court decides that, there should be no bail at all? We're going to, and I think you used the word remand before, and that means hold them in custody.
Right. So to remand a defendant is to hold them in custody without bail. So you don't have any bail, you're going to be held in custody on remand.
Are they still doing any of that under the new bail reform law, or is that something that, they don't do anymore?
Well, yes, certain cases you can still be remanded on, especially homicides. Homicides are typically the case where you're probably going to be remanded on a homicide. So if someone loses their life, you'll probably be remanded. And other serious cases where a court may think because this charge is so severe and you're looking at that much time, remand is what should be issued.
So what's the real difference between, the old bail reform law and the new bail reform law?
Well, I think, and there's actually like 3 steps to that, because you have the initial time where there was really no bail, law per se, right? It was just the law of why bail should be set and what factors the court should look at, like I said, community ties and so forth. Then there was a bail reform that came up a few years ago where there were many more charges that are listed. So there's the list of charges where if you're charged with that crime, bail will not be set unless there are additional factors for bail to be set, such as your warrant history or something. But then recently there was an amendment to the bail reform law where some charges were removed from that list. So for example, A1 drug felonies were now removed, where now bail can be set on those crimes.
I see. So, there are more crimes where bail can be set as opposed to where it would be, an automatic remand.
Well, on automatic release, actually. So with the bail reform, the charges listed are automatic releases. So you'll be released automatically if you're charged with certain crimes.
Sure.
Right? There are certain crimes, such as domestic violence crimes, are not automatic release charges, right?
Okay.
But let's say a petty larceny, which typically you'd get released anyway, are now listed as there's no bail. So we don't even have to make a bail argument because this is a no bail charge.